Thanks, Johnny, and I also want to hope you can hear me. Can you hear me all right? Thank you, Vaughn, for that presentation. As a resident of Davis County, I'm glad you're watching over my records, so thank you very much for that. I feel like they're in good hands. And this is a great backdrop. Feel free to zone out and stare at the fish. It reminds me of when I was a kid. My parents had an aquarium that my sister and I would just sit and stare at in the mornings. So I won't feel bad. But hopefully I can keep your attention talking about road liability beyond RS2477. I think the reason for that is RS2477 has been in the news a lot lately. It's been a huge issue with some of our counties. But there's a lot more to road liability than talking about RS2477. I want to refer you also, before I get going, to the handout that is online. It's a PDF. It is hyperlinked so that you can hit the statutes that I'm talking about, the case law that I'm talking about. It'll take you right to them. It's in public domain, so it should take you right to the actual document if you want to follow what I'm talking about here today. My presentation is going to diverge from that a little bit, but it'll be pretty much pretty similar to what I have in that handout. So let's go ahead and get started. When we talk about road liability, oftentimes this is what comes to mind, right? Now, this isn't something that the governmental entity was responsible for, although someone probably claimed it, because you claim all sorts of things. But this was due to fog. This is down in Texas, multi-car pileup. But this is usually what we think of when we think about road liability. We usually don't think about this. This is the Lund Highway heading into Cedar City. Now, a lot of the photographs I'm going to use are photographs from state highways because I couldn't find images that were okay to use of county roads. But we have some really great roads in Utah, and just scenic, fantastic roads. And so I've got a few photographs of those today to help the time pass better. But there are issues here, though. So what I want you to sort of change in your head is when you look at this and you see dollar signs if the county's at fault, I also want you to look at this and see dollar signs if the county's at fault, because both of them can wind up costing the county a lot of money. Let's talk a little bit about how we get roads. This is Cottonwood Canyon Road down in Kane County. There are three ways that we come up with roads in Utah. The first is when counties purchase or condemn land. Now, purchasing, interestingly enough, doesn't have to be for a contemporaneous building of the road. You can also buy property to build a road if you're planning to build it within the next 30 years. So if you have a long-range plan, like you're supposed to, you set out your transportation corridors within your county, you can begin purchasing that property toward those corridors decades in advance of when you're actually going to build the road. Now, the other method, of course, condemnation. I think we're all familiar with that. I could do an entire presentation on condemnation. I'll spare you that today. The next way is through dedication. Now, oddly enough, this is actually probably the most common way currently that the counties in Utah come up with their roads, because every subdivision that gets approved has public roads going through it, and when it gets approved, those public roads then become, when it's dedicated, when the final plat is dedicated, they become county roads. We also have general plans, road maps. Those are usually guidelines. There's no obligation for the county to build those roads, but they can't build them unless they conform to the general plan. So just something to keep in mind. And then finally, we have consistent public use. What is this? Well, this is if a road is continuously used by the public for a period of 10 years, it becomes a public road. And that's, historically, that's how most of the roads in our counties have come into being. They've come into being because way back when, sometimes even when Utah was still a territory, the roads were being used by the public. They've always been used by the public, and now they're just considered to be county roads. So most of your roads are probably roads that were created through consistent public use. So let's talk a little bit about the classes of roads that we have. This is looking down onto Height Bridge in Glen Canyon. We have Class A roads, which are state roads. We have Class C roads, which are city roads. And then we have Class B roads, which are your county roads. These are all the roads outside of the municipalities in the county that are designated by the county executive as county roads. The county owns them in joint title with the state. So they are owned by both the state and the county, but the sole jurisdiction of these roads is the counties. All right? And then we also have Class D roads. And I say these are county roads, but I say that with a question mark. These are strange roads. They're all public roads outside the municipal boundaries that are not designated as county roads. However, the title in those roads is in the state and the county has jurisdiction over them. So go figure. They're county roads that aren't designated as county roads, essentially. So that's what Class D roads are. They're scribed on state maps. I think this came into being around the time that the RS2477 issue sort of erupted. These are often just dirt roads that are not maintained, but are nonetheless considered county roads. And as I understand it, I've been told, although I haven't been able to confirm it in the statutes, that there's a difference in funding between the two, where you receive state funding to maintain Class Bs, but not Class Ds. So that is the main distinction there. Now, county roads, whether they're Class B or Class D, can pass through municipalities, and those are still county roads where they go through municipalities. However, where they're going through the municipality, the law that applies to the road within the boundaries of the municipality is the municipality's laws. So they set the speed limits, they apply the law there, but still nonetheless, still is within the county's, otherwise within the county's jurisdiction. We also have temporary right-of-ways over state lands. This came about in 1992. The state said, okay, all the roads that go across state lands, those are now county roads. If they existed prior to the passage of that act, which occurred in 1992. However, the counties were supposed to apply to determine the status of those roads to the state. I don't know how many counties have done that. I suspect very few have, because there's really no upside and only a downside to doing that, because there are different standards of proof you're going to have to use if you want a permanent easement on that road going over state land. So for example, if it's SITLA land, SITLA has a mandate to make money for its fund that funds the public schools. So if the road, making the road a county road, doesn't fit that mandate, you don't get a permanent easement on that road. So there's really no impetus for the counties to go through this process of trying to get permanent easements established across state lands, where their roads cross the state lands. And I doubt many of you have done it since 1992. I could be wrong. Yes?
The counties are purchasing those easements across state land now.
Okay.
From SITLA.
From SITLA.
Yeah, so that they can maintain.
Their mandate.
And
Okay.
They're actually doing that through the community impact board.
Oh.
And getting the funds there. Community impact board has determined in a lot of those cases, because those roads have value for extracting minerals and so forth.
That makes sense.
They want to maintain, because SITLA may sell that section to somebody who doesn't want that road anymore.
Right.
The county has an interest in it, so the counties are purchasing. They purchased nearly all of the B road easements, and now they're going to look at purchasing the B road.
Okay. Okay, so I don't know if you all heard that, but apparently some counties at least are buying
I think all of them.
You think all of them are buying, purchasing the easements across the state lands, even from SITLA, because if you pay SITLA for it, then they satisfy the mandate.
Well, that's the only ones they're purchasing is the ones across SITLA.
Yes, because the other ones you can just get a dedication from the state. Okay, great. So, and roads exist until they're formally vacated. Any other action that the county takes does not vacate the road unless there's an actual passage of an ordinance, a resolution, a court order. Unless there's something formal, that is still going to be considered a county road and within the county's jurisdictions. Clerks and recorders not allowed to remove a road from any of the maps in their offices unless this formality has been satisfied. When it is vacated, it vacates both the county's and the state's interests in the road, unless it's a road that was dedicated under RS2477. If that's the case, then the state, even if the county goes through this process, the state maintains its right in the road. So what this means is that you're stuck with your roads unless you go through the formal process of getting rid of them. One thing you can do is you can temporarily close a road, but it has to be temporary. There are certain processes that you have to go through. It won't count as an abandonment if you do it formally, so you have to do it by resolution or ordinance. And you have to annually reauthorize it, and it can't last for more than 2 years. If you do that, then you run the risk of having it deemed an abandonment. And it also has to be necessary to mitigate or correct harm to nearby property. So, for example, I recently dealt with a county that had a road that they had closed, and they had it closed for a number of years. It used to go over a dump, and they didn't want anyone going down in there and continuing to dump garbage down there. They had a hard time keeping people from doing it, so they closed the road. But the problem is they kept the road closed for well beyond 2 years, so technically an argument could have been made, and thankfully it wasn't in this case. It could have been made that that road had then been abandoned and no longer, or should have no longer been considered a county road. And I don't believe it was done formally either. So this is something to keep an eye on in your counties as well. So going back to when injuries arise, I call this injury from use. This is something that is wrong with the highway or the road that causes an accident. This is the most common way this arises. So first of all, let me say that unless you can find an exception to liability within the Governmental Immunity Act, if you are responsible for whatever caused the accident, then you're likely going to be dealing with liability. You're likely going to be liable. There's likely going to be no way to avoid the liability unless you fall within an exception. This is because counties have what the courts call a non-delegable duty to exercise due care to maintain the roads in a reasonably safe condition for travel. Okay, so if there's something wrong with the road, some condition on the road that no longer makes it safe for travel, counties are responsible for that. They have a duty to that. They can't delegate that duty to anyone else. They're ultimately responsible. So they can contract with someone to repair a road, but the duty to keep the road in a safe condition is still the county's. All right, so you still can end up being liable in a suit situation for an accident that arises from, for example, a shoddy repair job. All right. The state has waived counties' immunities for negligence and defective or dangerous conditions of the road. So if the road is in a defective condition, if it's dangerous, you have no immunity from those kinds of suits, unless you can find an exception. And there are a couple exceptions that we see frequently applied in these cases. They are the discretionary function exception and the latent defect exception. So let's look a little bit at those. So you're likely not going to avoid liability unless you fall under one of these exceptions. As I said, the most frequent ones are discretionary function and latent defect. I'm a little bit behind on my slides, sorry about that. So let's talk about discretionary function. I'm going to go through, I listed a lot of cases in your handout. I'm going to go through a few of them and show you where the courts have rejected the defense of discretionary function. And let me just explain a little bit about discretionary function. This is where you say to the court, you say, yeah, you know, maybe we shouldn't have engineered the road that way. Maybe we should have gotten to that project a little earlier. Maybe we should have known that there was a huge pothole in the road that cars would fall into. But It was within our discretion. We had more important things to spend our money on. We had more important things to worry about. We had other roads that were even worse condition. So this was a discretionary function. We shouldn't be held liable for that because we have to choose. We only have a limited amount of funds. We have to choose where to spend it. We spend it on a different road, so we shouldn't be held liable for this road. So let's see where the courts have said, no, we're not going to give you that. One situation where this has occurred, and this is in quite a few cases, where governmental entities have said, we chose the orange barrels, you know, those orange construction barrels when we were doing our construction project, instead of the cement barricades, all right? And the plaintiff is saying, you had, you know, those provide, I've got oncoming traffic, those provide little defense. You should have had the cement barricades, not the orange traffic barrels. And the governmental entity has said, well, we chose the orange barrels. We exercised our discretion to choose the orange barrels. And the court said, no, that's not discretionary. It might be discretionary in your roads manager to make that choice, but it's not the kind of discretion that the statute's talking about. The statute is talking about the kind of discretion where you actually make a policy decision. So you've done studies, you've looked at the costs, and you decided as a county, you know, this is the potential harm that could come to our citizens if we use the orange barrels instead of the cement barriers. We, as a policy, are decided just to use the orange barriers because it's going to save us X amount of money, even though we know that there's a potential offset of that of more injuries to our citizens. So if that is the kind of discretion you're talking about, then yeah, you probably will get a discretionary function immunity. But just for a decision on the fly by whoever's in charge of the construction to use barriers instead of cement, to use the orange barriers instead of cement, that's not going to be discretionary function. One of the famous cases about this is the Carroll versus State case. This is a case where the county roads manager, I think it was a county roads manager, it might have been a state road engineer. A road had washed out, they put in a new road. So to bar passage on the old road, they put a pile of dirt in the road. And it washed out. And so someone came along, it was actually a couple tourists came along, they saw a junction in the road, they weren't sure which road to take, they took the old road. And they're going down the old road at 60 miles an hour, and the barrier of dirt isn't there, there's nothing there, it's straight as far as they can see, except there's a huge gap in the road that they don't see, and they go right into it and suffer injuries. The defense was, well, this was a discretionary function. The court said no. The choice to use a pile of dirt instead of something better to mark that this was a closed road, that's not a discretionary function. Another rejected discretionary function argument was about designing traffic controls. Now, I use designing in quotation marks. You'll see in a minute why. This happened when someone was trying to go through an intersection and their traffic light went green, but unbeknownst to them, the other traffic light stayed green. So both lights were green. They drove out. They got T-boned. And the government defending the case said, well, that was a traffic system design, safety design. That was a discretionary function. And the court said, no, not really. The court said, basically, this was a malfunctioning traffic semaphore that was put in place by whoever you hired to put in the traffic semaphores. This was not some policy decision that you had made or a result of a policy decision, so you're not getting discretionary function immunity. Now, if it had been a true design flaw, so let's say you had a study done, an engineering firm came and said you need lights here, you need lights there, and you need lights here, and you had a certain amount of funds, and you said, well, we can put in these lights here, so that's what we're going to do. We're not going to spend our money to put lights over here. And then someone got into an accident and said, you should have put in traffic lights on this intersection, you chose not to put traffic lights in. That's a different story. That is discretionary function. Why is it discretionary function? Because it's a policy decision. You're looking at budgets, you're doing studies, and you're making tough choices that governments have to make about where to spend those funds. Let's look at some cases where it's been accepted. So it's been accepted for railroad crossing devices and signage. Counties have a duty, and they still do have a duty, even in light of these cases, to warn drivers about railroad crossings and to regulate them as well. However, in these cases, oftentimes what happens is there's just a sign for a railroad crossing. There's not arms coming down, or let's say there's a sign, but the sign isn't lighted, and someone gets hit by a train. And they claim that the county really should have had lights there, or that the county really should have had crossing arms that came down there. And courts had, several times over, I've got 4 cases listed, have said, no, this is a discretionary function. What kind of sign, of device to put in at a railroad crossing, this is a choice that the county makes. This is entitled to immunity. You're not, well, you'll get sued, but you're not going to get a judgment entered against you for that kind of suit. Same thing for signage at railroad crossings. Also, the decision whether to raise a permanent barrier. This is the Keegan case. I don't know how many of you are familiar with that, but what happened in the Keegan case is that there was a cement barrier next to an overpass. I want you to sort of picture this in your mind. A car, because of some flooding, loses control and then hits the barrier and slides up the barrier and into the foundation of the overpass, causing significant injuries to the passengers of the car. What they found out is that over time, the road next to the barrier had been repaved and repaved and repaved and repaved, and each time raising the pavement just a little bit, but the barrier stayed the same. So the pavement was rising, the barrier was in effect dropping, so that at a certain point, it became very easy for cars to go up that barrier and slide down and hit the foundation of the overpass. And the plaintiff said, well, government, you should have raised that barrier every time you repaved, because that's just negligent not to do that. And I think this was, this was UDOT came back, and fortunately UDOT said, well, you know what? We actually studied that. And we looked at how much it would cost to raise that barrier every time we did a repavement. And we looked at how likely it was that an accident like this was going to happen. We decided that it would, based on cost-benefit analysis, be better just to keep repaving it, and then at a certain point in the future, when it got too bad, at that point we would raise a barrier. That hadn't occurred yet, so that was a discretionary call. We should get discretionary function immunity, and the courts agreed in that case. All right? So let's look at latent defects. These are defects that no one knows about that are in the road. Oftentimes they're because of an engineering error, maybe a defective material that was used in the road. The question on these cases, it's usually a question of fact. So, because it's latent, right? What did the county know? When did they know it? Because it's a question of fact, usually you're not going to get out of these cases on a motion. These cases, you're either going to have to settle or they're going to go to trial. All right? Because if there's a question of fact, it goes to the jury. That's the Picked Gun Club case, where it talks about that being a fact issue. Now, some fact issues. A loose water meter cover. This is an older case up in Ogden. Instead of welding, the city had a water meter. They abandoned the water meter, but instead of welding the top lid of the water meter on, they just let the weight of the lid hold it in place. An accident resulted when it flipped up, and the question was this the kind of defect that the city should have been aware of, should have foreseen, and done something about before it occurred? It went up to the court. I think it was that time the Supreme Court, before the Court of Appeals was created, and the Supreme Court said, this is a fact question. We don't know. The jury has to figure this out. And sent it back down. Same thing occurred with a defective manhole cover. Same kind of issue. Manhole cover, some people who lived nearby said, oh, that's been that way forever. Everyone knew about it. The city knew about it. The city said, we didn't know about it. And again, the court said, you know, this is a fact issue. Who knew what? That's quintessentially a jury decision. Send it back, let the jury decide. So, those are some examples of latent defect. Now, I need to say a few words. I know it's beyond RS2477, but I need to say a few words about RS2477 roads. These roads are unique in that state statute gives governmental entities, especially counties, broader immunity over these roads. So if the accident occurs on a road that was dedicated to the county as part of RS2477, their county is not required to maintain the road, it's not required to improve the road, it's not required to put traffic signs on the road. And if the road is not classified as an A, B, or C road, meaning a Class B county road, then the public travels it at their own risk. So in other words, if you get a suit that comes in, and it's one of these RS2477 roads, you probably have a good shot at an immunity defense because the statutes give you very, very broad immunity on these. I think it's kind of problematic because the courts for 100 years have said that counties have a non-delegable duty to maintain all their roads and safe travel conditions. So I think it hasn't been decided yet, but if those two issues ever come head to head, I think it'll be interesting to see which way it comes out. I'm not so sure that the statute is going to prevail. So let's look at injuries from the actual construction or improvement or maintenance of the roads themselves. So this is not some defect in the road or something in the road that causes an accident. These are usually harms to real property. And again, we got discretionary function immunity that applies in a lot of these cases. So a county's decision to build a road, a county's decision where to build the road, and a county's decision developing plans to build a road, these are all immune decisions. So if someone brings a case against the county alleging some sort of negligence in any of these areas, counties will be immune from those suits. There's no immunity, however, for executing those plans. So if you go out and in the process of widening a road or building a road, you damage a citizen's property, real property, you will be held liable for that because there's no recognized discretionary function immunity, unless the huge exception to all of this are takings claims. Takings claims are not the same as any other claim that can be brought against the county. They don't play by the same rules. There's no immunity for takings claims. To bring the claim, you don't have to file a notice of claim. A lot of people don't know that. You can just bring the suit under Article 1, Section 22 of the Utah Constitution. Don't bother with informing the county that you're going to do it ahead of time. Don't go through the processes. There's no one-year limitation for bringing a takings claim. They have their own statute of limitations. It can be as long as 7 years after the taking, and someone can still bring a claim against the county for taking their property. And they're also very factually intense. So, for example, let's say that the county concedes, yeah, we took your property to build this road, but we just don't think that we have to pay what you say we should pay for the property that we took. Still a fact question, still going to a jury. So in other words, these cases are usually somewhat expensive because you're going to go to trial unless you can get it resolved some other way. So there are more than one kind of takings. The ones that most apply to roads are physical takings. This is where the government comes in and physically occupies some of the property. It's pretty clear-cut. It's fairly simple. I put simple in quotation marks because you still have disputes about property value. I have had 2 or 3 of these cases lately where the question really is the road that was widened and improved, is that a county road? And so that's not a very simple question to answer. So they can get a little complicated, but usually it's just a question of, did you take the property? If you took the property, what's the fair market value of the property that was taken? The other kind of taking is an unlawful exaction. Now, exactions are when the county says to a developer, yes, we'll give you a permit to build this subdivision, but in return, you need to build a road, not in the subdivision, but alongside the subdivision to service the subdivision. Something like that. It's an exaction, something they ask for in return to approve the application. This is not straightforward. They're often complex, and I'll get to the reason why in a little bit, but they're extraordinarily frequent. Your governments are dealing with exactions and exposing themselves to the risk of an unlawful exaction probably weekly, because every single subdivision that gets approved has an exaction component to it. An exaction component means if you're asking for too much, you're exposing yourself to a takings claim. All right? So let's talk a little bit about what that requires. The courts have said, and this is now in our state code, that you need two things for an exaction to be legal. It doesn't rise to a taking unless it's illegal. So as long as it's legal, you're okay to require an exaction. The first step is this thing called an essential nexus, which is legalese for an essential connection between what's being asked for of the developer and the government's legitimate interest. So, a public road, if you're asking the developer to put in a public road, it probably meets this part of the test. However, if you're asking for vacation homes for your county commissioners, probably doesn't meet that part of the test. Now that's an exaggeration, but this is a lot where this law came from, is that county governmental entities were asking for way too much from developers, at least the developers thought so, right? They thought, look, you're asking for way beyond what you need to service the subdivision that I'm putting in. You're using this as an opportunity to extort from me because I really need your approval for this application, something more than what you really need. So this law developed. So we have this essential nexus, and it also has to be related. The exaction that's being asked for has to be related to the impact that the development's going to have. So it has to be related in nature, and what that means is that it has to be designed to mitigate the problem that the approval is going to cause. So for example, if you're going to approve a 500 lot subdivision and you only have a small road that's servicing that, you can ask for a road that can service that kind of volume. You can't, however, say, you know, our council chamber is looking pretty shabby, we really would like some mahogany here. That isn't related in nature. So the question you ask if it's related to nature is this solving the problem that the development is creating? If it is, you're good. The next question is the extent. Is it related in extent? So to kind of explain what this is it's more of a cost analysis. So if it costs the developer $4 million to put the road in, and the county the problem that the development is causing is, say, only a fifth of that, and the county otherwise just has some more areas that it really wants to get the collector road to, and they charge the developer for the entire road, then it's not related in extent. It has to be almost a dollar for dollar equivalency on the cost to the county and what it's asking for from the developer. So for example, famous case, about 4 cases actually, called BAM Development versus Salt Lake County. They went up, they came back down, they went up, they came back down, they went up, they came back down, and then they went up again to the courts on this case. And the way it finally turned out was the county was asking BAM Development to put in a road next to their subdivision. The road was going to cost $6.7 million to put in. They were asking BAM to contribute $84,000 as an exaction. When all was said and done, and who knows how many hundreds of thousands of dollars of attorney's fees had been spent, the analysis was this. The development is going to cause a 5% increase that will need to be handled by that road. 5% of the cost of the road is around $340,000. The county's only asking for $84,000. Great, no problem. Exaction is fine, all right? That's the kind of analysis that exactions have. Like I said, your counties are doing this weekly. Be very careful. You're exposing yourself to a suit every time that's not lining up just right. All right? So what are my recommendations, my takeaways? If we look at injury from use, the first thing I think you should ask is, whose road is it? Is it a county road? Is it a state road? Is it a municipality road? Is it an RS2477 road? Because you're going to have different defenses to all of those, and oftentimes it's not your road. You don't have jurisdiction over it. If you don't have jurisdiction over it, you shouldn't be paying anything, and you shouldn't be worrying about a lawsuit. I know a lot of plaintiffs' attorneys that when they get in a car accident, they don't know where the road is, they just sue everybody. All right? They sue everyone who could possibly own the road. If it's not yours, get out of it as fast as you can. Were policy considerations in play? If this is a construction accident where there was construction on the road and an accident resulted, was the cause of the accident the result of any policy that you can point to? Were there discussions? Were there studies? If there were studies, you probably have a good shot at discretionary function immunity. And then finally, if a defect is to blame, was it an obvious defect or was it a latent defect? If a latent defect, you have a good shot at immunity, but then again, you're going to have to go through the entire case in order to be judged immune. All right. So for the other kind of injury, the injury to real property from construction, improvement, and maintenance, a couple recommendations. One is to make sure you document agreements with real property owners. I have a case right now where we had a roads supervisor who felt that when he was out widening county roads, that a handshake was as good as gold, and he didn't need to get written permissions from property owners to widen those roads. Well, you know what happens, right? He felt his handshake was good as gold. So did the other guy, by the way. He's also that kind of guy. But they didn't understand one another. And when that road got built, there was a lawsuit. Because one person understood one thing, one person understood another thing. Make sure your road supervisors are getting written authorizations when they go out to widen roads or go out to get roads. You might not know it because I can tell you that a lot of the people at that county did not know that this was the way this was being done. So please check up on that to avoid liability. Also, when you get a case like this, sometimes if you look at the cost of litigation, you look at how much the verdict could be, and you look at how much it would just cost you just to condemn it, sometimes it makes more sense just to condemn it. All right? If you look at just comparing the costs of each, so that's an option that I want you to keep in mind and be mindful of. Hopefully, if you do these things, we can avoid these kinds of results for you in the future. Thank you for your time. Are there any questions? All right. Oh, yes?
I have a question relative to use of those roads.
Mm-hmm.
Down in our area, we have a lot of OHV recreation where we have actually allowed for road for the RS2477 or otherwise OHV use. In some cases, they're paid. OHV manufacturers specifically label those products as non-strong highway use.
Okay.
What liability does the county have or cities that are on that?
Okay, so the question is, if you have OHV trails that are considered county roads, and people are riding on them with OHVs that are only for paved roads. For non-paved roads. But some of the roads are paved, is that what you're saying? Okay, so some of the roads are paved. And I would say that you still are probably looking at some shared liability, because what the defense is going to be, you shouldn't have been driving that vehicle on this road. You were, so you're going to be negligent, but it's going to be a question of contributory negligence. So the question is, what percentage is going to be applied to the county versus the driver? And unfortunately, that's a question of fact, and it's probably going to be very difficult to get out of on a motion. Any other questions? All right, thank you very much. Oh, sorry.
So now you're seeing a lot of long distance road biking events. Say they come into your county on paved roads that the shoulders aren't that great. How about them if they wreck on paved roads? Is the county liability for such events?
Okay, so the question is, if you have road bikers that are coming through, touring through your county, and they're on these paved roads that have very small shoulders, again, I'm sorry to say you're looking at a fact question, because the argument that they're going to make is you have an obligation to make sure that these roads are safe for travel. It was foreseeable that road cyclists are going to be coming through here, so you had an obligation to give us safe travel on these roads. On the other hand, the county will respond with, you saw the shoulder of the road, and you chose to ride on it anyway. So you at least share some of the negligence here. So again, unfortunately, you're looking at a fact question that's not going to be resolved probably in motion. You're probably looking at going all the way through trial unless you settle.
Wouldn't that also be a policy issue, so you don't need to make the legislative choice, not to do
Oh, good point.
access for the cyclist?
Yeah, so the comment here is that might also be a policy decision as well. You might have discretionary immunity. If you have, the thing is, you can't create a policy after the fact. So if you're going to, up front. So if you're looking at it and you're saying, we just can't afford to purchase the extra property it'll take to put on these shoulders, and we've looked at that cost, and we've made that cost decision, yeah, you might have a good shot at discretionary immunity. Good point. Anything else? Yes?
What about when you include any special event permit that the event provider or promoter recognizes that this road has a narrow shoulder and that the road is not in the greatest condition and will sign off on any liability of the county? Will that have any merit at all?
So the question is, if you have a special event permit and the person running the race or the tour signs off, recognizes that the road is not in the best circumstance, will that have an effect if it has an immunity clause or an indemnity clause, I guess, from the organizer? I would say the indemnity clause is probably enforceable under those circumstances, but I haven't looked into that in particular, so I'm sorry, I don't know for sure. My guess is it would probably be enforceable.
Best thing to do with those is to also require that they get a waiver from every participant, that they also recognize that.
We do as well.
Okay. All right, thank you. Thank you very much.
Thanks, Mark.